sense, Mr. Green?
Can you repeat the thing about, obviously Bernadette's kind of the key person at CU that knows
Sure.
most of this stuff. So,
I agree.
if you want to know what's going on, information from her would be important to you. So why shouldn't I ask her to verify facts to you?
Because I'll ask her to do that. She is the witness for my clients, and so you don't really need to be reaching out to her, whether you're including me or not including me. You shouldn't be contacting CU officials and asking them to respond to your inquiries about this litigation. There's a process for you to ask questions. It's called discovery. And that's what we're, sort of getting started with today. So to the extent that you have, questions related to the underlying facts and evidence in this case, you can ask those questions of CU or of individual employees like Bernadette Stewart by reaching out to me for those things. Okay?
So it doesn't really answer my question. So you stated in one pleading that CU has no knowledge or information as to whether Green wants to continue working. Do you recall that statement?
Yes, in our answer.
Okay. So obviously, whoever told you that, you could confirm from Bernadette, for example, that statement's completely false. So why wouldn't it be prudent for me to have Bernadette clarify to you that the statement you filed to the court was completely false?
It's not your role, Mr. Green. So we don't need to get into an extended exchange about this issue. I'm asking you to stop emailing CU employees with questions about this litigation. Now, let me be clear. I'm not telling you not to email CU employees about other issues. You work there, you may have questions about your employment, and you should feel free to email them about those things. But when it comes to the allegations in your lawsuit, you don't need to be reaching out to CU employees. You should reach out to me, okay?
Is there? So I'm asking for example, I'm asking CU to verify to you that a statement you made to Boulder District Court is 100% false. Is there a rule that would prohibit me or discourage me from clarifying that to you?
I mean, if you want to tell me that that's false, that you can. I said that I don't know. I lack information and belief about that statement.
No, that's not what you said. That's not what you said. You said CU lacks knowledge or information. Okay? So you're speaking
I
for...
was answering on behalf of CU.
Okay, so you made a statement that CU has no knowledge or information about whether I want to continue working, and your statement is false. Bernadette knows that's false, so I asked Bernadette, for example, to clarify that the statement you made under oath to the district court judge is completely false. What rule would prevent me or discourage me from informing you that you made a false statement to the judge?
Nothing. And that's not what I'm telling you. I'm asking you to stop emailing CU employees and asking them questions about this litigation. That's not really an appropriate thing for you to be doing in litigation. So I'm asking you to stop doing it.
It's because it's inappropriate according to you.
According to the rules.
Which rule?
Well, you're a plaintiff and you've sued CU, and you shouldn't be reaching out to individual witnesses asking them questions that are not funneled through the litigation process. Okay?
So you're not referring to any rule, you're just calling it inappropriate.
Well, I'm talking about the civil rules of procedure. Rule 26 about the types of requests for admission, and that sort of thing. If you have a request for admission, then you should put that in a Rule 26 discovery request and direct that towards me.
Okay,
not in an email to Bernadette Stewart. Okay.
Okay, I'm assuming that if you, for example, made a false statement to the judge, which you did, it would be appropriate for CU to inform you that you'd made a false statement under oath to the judge, and you're saying that would be inappropriate for me to make that request. Am I missing something?
To CU, to make that request to someone at CU like Bernadette Stewart, yes, that's inappropriate.
Thank you.
Mr. Green?
Yeah, so you're telling me that I'm not entitled to attorney fees since I didn't use an attorney, But you're asking for me to pay your attorney fees. Is that correct?
No.
Yes, you did. You said, respectfully, we ask for attorney fees in your answer. So you're asking for attorney fees from me, but I can't ask for attorney fees from you. Is that your point here?
Well, as a matter of fact, yes, I could ask for attorney's fees because I'm an attorney. And yes, you cannot ask for attorney's fees because you don't have an attorney. But we included that in our answer. But before we would even attempt to recoup attorney's fees, we have to go through a whole process where we would file a motion and send in our invoices to the court and all of that kind of stuff. So we're not actually asking for attorney's fees, but we included that as a potential down the road should we prevail in this lawsuit. So to be clear, we are not asking for attorney's fees. And also to be clear, yes, we are entitled to ask for attorney's fees and you are not. So I don't know, but we're not asking for attorney's fees at this point, just to be clear. But we included that as a potential thing we could ask for in the future in our answer, okay?
Wherefore, having answered plaintiff complainant, CU requests the court enter judgment in his favor against plaintiff and award CU its costs, attorney fees, or any such other relief as the court just deems proper. You just told me you didn't ask that, and your motion asked that. You just lied to me.
No, I told you that I agreed with you that we included it in our answer, Mr. Green.
No, you said you didn't.
Before we can actually proceed to recoup attorney's fees, there's another step in the process, and we're not there yet, and we may never actually proceed with that.
Yeah, you just told me you didn't ask for attorney fees, and your motion says awards its costs and attorney fees or other such relief as the court deems just and proper. So you lied to me in this deposition.
I'm not lying to you. I'm telling you, I agree with you that is in our answer. What I said was, we are entitled to seek our attorney's fees if we want to, and you are not because you don't have an attorney.
Mm-hmm.
However, there's another step before we would actually recoup attorney's fees or attempt to recoup attorney's fees. We included that in there. I'm just clarifying with you that we did include that in our answer, but we are not seeking attorney's fees at this time. There's a whole other process involved in that.
So you're not seeking attorney fees, but your motion says we request the court enter a judgment in its favor and award CU its costs attorney fees. You're not seeking attorney fees, but you told the judge you are seeking attorney fees. Let me ask this: what do you think it looks to the integrity of the office of Phil Weiser for you personally to ask me to pay Phil Weiser's attorney fees as potentially the lowest paid classified staff person in the state employment system? I mean, I'm reporting violations of the Power Act, and you're saying that me reporting violations of the law by the state university system warrants you to ask me to pay the attorney fees of Phil Weiser. I mean, integrity-wise, Phil Weiser's running for governor. How do you think that looks to the public? Weiser wants me to pay his lawyer fees?
Mr. Green, that's not really an issue that's germane to the conversation we're having today, so I think we should move on.
It's in your motion. So it's not appropriate for me to quote you to the judge? Is that what you're saying?
When it comes to the settlement discussion, when I'm telling you what I think that you could recoup and what's possible for a settlement or recovery in this case, this is a discussion between the attorney and the plaintiff who's unrepresented, and this is not fact gathering or legal argument. This is just us discussing the case. You know what? You may disagree with me, Mr. Green. You may say that I'm wrong about what limits your damages or not, and that's fine for you to believe and try to make those arguments. But this is a discussion about your case, not a legal argument or a deposition or something like that. Does that make sense? This is the meet and confer.
Okay, so you just said this is not a legal argument, and a few minutes ago you said those don't apply to this lawsuit at all. That sounds like a legal argument. Or you
if we put it in a pleading that we filed with the court, then it would be a legal argument. But I'm just telling you what our position is right now in terms of what you could possibly recover in this case.
Yeah, and your position, as you stated in the last couple minutes, is those don't apply to this lawsuit at all. This is not a legal argument. I mean, it sounds like a legal argument to me. Those don't apply to this lawsuit. That's not a legal argument.
Okay, Mr. Green. Well, let me ask you a different...
Yes, the liquidated damages provision has been violated because it says 100%. There's nothing in the statute that says authorize 100%. It's varied according to the nature and severity of the breach. So the 100% clause violates the liquidated damages clause.
Okay.
That makes two. At least two. Okay. Now, if you've read the settlement agreement, you notice that the first sentence says, do you recall what the first sentence says, or do you want me to quote it for you?
I don't recall, Mr. Green.
Okay. The first sentence says, one-time payment of $100,000. Does that sound familiar?
Yes.
And what does the second sentence say?
I don't recall.
It says it will be divided into 12 monthly installments that CU can stop at any time if I make a negative statement. Does that what does Phil Weiser think about that? One-time payment, oh, by the way, just divided into 12 monthly installments we can stop at any time. What's the position of Phil Weiser on that? CU trying to sneak that past me?
I don't know.
What's your position on it? Do the first two sentences contradict each other? I'll put it that way.
They're trying to reach a settlement with you, Mr. Green, and they are trying to resolve their prior disputes with you. I don't know what else to say. They were offering to pay you $100,000.
Yeah, you said that the offer is in good faith. That's in the filing, right? You said good faith. You used that term.
I believe so. Yes.
Yeah, you did. Okay, so the first sentence is one-time payment of $100,000. The second sentence will be divided into 12 monthly installments. Would you call that good faith?
I don't know, Mr. Green. Again, we're not here to have this kind of a back and forth about what I think about what's right and all that sort of stuff.
You said that the offer was in good faith. The first sentence is one-time payment of $100K. The second sentence is will be divided into 12 months installments that can be 100% liquidated at any time. Is that good faith? You said it was good faith. Is it? You're still alleging that that's good faith, those first two sentences?
Mr. Green, again, I'm not going to get into this sort of, line by line, good faith, sort of back and forth with you. We've made our arguments in our pleadings. That's where we will continue to make our arguments. We don't need to argue that here at this meet and confer.
Okay. Well, you said good faith, and I'm assuming that you think that's good faith, but it seems like a pretty weak argument.